Let's explain those Badlands. That's a hell of a name.
Alrighty then. Good evening, ladies and gentlemen. Welcome to Why We Vote. It's Friday.
I just realized I don't have the chat up, and I got a little panicked for a second. So hang on, guys. I'm coming.
Oh no.
Yeah.
Whatever. You're freezing.
I am really cold.
No. No, your camera's freezing on me.
I don't know where that would be.
Is it doing it?
Down.
Is it doing it in the chat?
Do I look frozen to you guys?
Not in the chat, but in the
down to.
No, it's only doing it in. It's only doing it in StreamYard.
So it's a you problem, is what you're
saying.
Oh
no, you are frozen you are frozen. You are. I'm looking now. You are frozen. Damn. You guys have a blizzard right now?
No, we got a little bit of snow, but it's really cold. And it's been super, super warm for a while, and now it's really cold.
Maybe it's freezing your Wi-Fi.
Da-da-da.
All right, guys. Welcome to the show. Man, gonna have a little bit of an interesting show tonight because we're gonna go actually a little bit off topic from elections, although Ashe is gonna tie it in wonderfully. And
it's all about elections.
Everything's about elections. I mean, literally everything. But
this Supreme Court case is specifically about elections, and all the justices agree. These powers have to be held by the elected officials. Everybody wanted it that way. Therefore, real elections are kind of an important part of any of this being legitimate.
I agree. I think we all agree. So, but let's get a word from our sponsors before we get into all that, and we'll start out here with Rise of Tiger.
What up, Badlanders? Are you ready to rock something new in 2026? Well, as always, we got you covered with the Rise Badlands Native Collection. Built from the rich tones and rugged terrain of the Dakotas, equal parts beautiful and brutal. Old roots, new vibe. Whether you got gators in your backyard or you have to take a bush plane to the post office, Badlanders are worldwide. Different dirt, same tribe. By the way, your friends at Rise have a deal for you. Show up at GART rocking your native gear, swing by our booth, and get in to win a free Badlands Rise hoodie of your choice. And don't forget, every order throws fuel on the fire of the Made in USA parallel economy. So grab something now at badlandsmedia.tv/rise.
All right, badlandsmedia.tv/rise, and I need to go and order the Moat shirt. Gordon's design. I got to order that shirt. I have to have that shirt.
Okay. I think you should then.
What's that?
I think you should.
Yeah. And let's go ahead and also talk about some soft disclosure. Fellas, got a quick question for you. Is your beard intentional? Or is it just kind of happening on your face? If it's dry, crunchy, or doing whatever it wants, that's not rugged. That is neglect, despite what Burning Bright says. Soft disclosure beard oil fixes that. A few drops softens the hair, conditions the skin underneath, and takes your beard from chaotic to dialed in. No grease, no overpowering fake scent, just clean ingredients that actually work. And now we've added the upgrade, our new Boar Bristle Beard Brush. Boar Bristle Beard Brush. Boar Bristle. Oh, I can't say. I said it 3 times fast. Engraved with the Soft Disclosure logo and ethically imported and finished right here in the US of A. Real bristles, real control. It distributes the oil evenly, trains the beard, and makes it look like you meant to grow it that way. And here's the move. When you grab a beard oil, you can add the brush for 25% off. Buy the brush by itself, full price. So do it right. Get Soft Disclosure beard oil and the new Boar Bristle Brush. Visit softdisclosure.com and level up your beard game.
You don't want your beard to rug your face. You want it to be rugged, not rugged.
Yeah.
Yours is looking nicer. I think your beard looks nicer since you got your beard brush.
Thanks.
Looks more intentional.
I'm doing
like
beard.
You meant to grow it that way.
I'm doing beard ASMR.
I don't hear it. Oh.
All right, so check it out, guys. Softdisclosure.com. All
and
right.
get the lotion and the lip balm and the tallow and all of the things as well. You support 6, I think we're up to 6 American small businesses now when you shop Soft Disclosure. So definitely head over. Softdisclosure.com, promo code Badlands.
Heck yeah. And so Ash, where do you want to start? We're going to cover a little bit of the Supreme. I honestly, I want to cover Gorsuch's.
Yeah.
Let's get into it. Let's do Gorsuch as well, because man, he concurred with the opinion. He had a concurring opinion. But dude, like what he went off. He went off on everybody. He's just like love it.
Yeah, he did. And so he takes like a page to concur in the decision. And it's about the authorities provided under the IEEPA statute. And, I have a goal. My goal in all of this is putting the government back in its constitutional boxes. So I'm not going to cheer for authorities being given to President Trump that are unconstitutional, that I wouldn't want President Obama or Biden or Clinton or Soros or Newsom to have, right? So looking at this, then we have to ask that question. Is this decision consistent with the Constitution and the authorities granted within the Constitution, or is it not? And I think it is. I think that it puts a great Gorsuch in particular. And the funny thing about this is it's 170 pages. And the reason it's 170 pages is because they're all bickering with each other. And like, well, Gorsuch said this, and he obviously misunderstood me. And if you read the footnotes, are hilarious throughout this thing. But when you look at what they're actually saying, they're not saying he can't do tariffs. They're saying this specific statute doesn't authorize tariffs. Now, I think the arguments that it's ridiculous that you would have the authority to regulate imports, but not apply a tariff, not apply a fee, that is a ridiculous argument. But the statute, the law as written, doesn't authorize it. That is also true. And so I think that's interesting, like, because I have clips of President Trump's press conference. I have timestamps, so I don't know if we want to go through some of that, but I think President Trump basically told everybody as much. He said several times, this was an open question, and now we have certainty. Now it's locked down. Now we know for sure, and we're going to do. And then he announced new tariffs during his press conference, because it's I really do think that we are and I've said this since Election Day, in a transformation program to put the government back in its constitutional boxes. And I'm pretty excited about it. I think we got good things going on.
Yeah, so a lot of people are kind of dooming out over this ruling, and I agree with Ash.
Or they had a chance to read it
before they had a chance to read it.
Because it took me all day to read it.
I said, and I've said all along that the Supreme Court should rule against that authority being delegated to the president on constitutional grounds. It's not his job. Article 1, Section 8 it's specifically with the legislature. And there's even a couple points in here where Gorsuch, says that it's exclusively to them. And is it exclusive? I'm trying to remember the exact word. I had it highlighted. But he says it so that in a way that they shouldn't even be able to delegate that away, even if they wanted to. Man, I'm going off here.
I think you might be talking about where he is rebuking Justice Thomas's response, because Justice Thomas was basically saying, as long as it's not a explicit law to restrict life, liberty, or property, they can delegate anything that they want. And Justice Gorsuch disagreed with that pretty extensively.
Yeah, let me pull it up here.
Okay.
All right. So here's the ruling, or not the ruling, but here's the opinion here. Starting up here. So yeah, do you want to read it, or do you want, how do you want to do this?
Sure, we can read it. I mean, this is 46 pages.
Yeah.
His concurrence is 46 pages.
Yeah, but I've only got it outlined for like 6 pages.
Yeah, I just had chunks that I wanted to to focus in on, and they're the chunks that have to do with elections.
Okay.
Specifically for this show, but whatever you want to go to first, let's do that, and then I'll talk about the parts that I have.
All right,
I need to save these images before I can pull it in.
Let's read through here. The president claims that Congress delegated to him an extraordinary power in the International Emergency Economic Powers Act, IEEPA. That's what we're going to call it, IEPA. The power to impose
IEEPA.
IEEPA. IEEPA. Okay. The power to impose tariffs on practically any products that he wants from any countries he chooses and in any amounts that he selects, applying the major questions doctrine. The principal opinion rejects that argument. I join in full. Now, do you want to lay out real quick what the major questions doctrine is? Because it's essentially important to understand.
It is. Just give me a second to finish pulling this in real quick.
Oh, okay. Well, I mean, I can summarize it. Major questions doctrine is so when an administrative state, and this is Gorsuch's overruled. This is the premise of his entire book. When an administrative state interprets a law or interprets a statutory law to make rules and regulations that have like direct impacts on the national economy or national politics, the scrutiny is called that you're supposed to assess whether or not they have that authority, the administrative state, whether the statute gives them that authority, is called the major questions doctrine. Now, I'm sure there's more technicalities to it. So when Ash gets that pulled up.
Yeah, well, yeah. So the major questions doctrine is when Congress explicitly gives delegates authorities to the president, it'll be explicit. It'll be they'll explicitly do it for major things. That's the question. Now, this has been interpreted a whole bunch of different ways over the time, and they all still disagree about it. And you can see that in Gorsuch's what is that? You can see it in Gorsuch's position, that they're all sort of taking a different position on it. In Kagan's concurrence, in one of her footnotes, she says, I understand something, I'm paraphrasing, but I understand that Gorsuch is attempting to get converts for his interpretation of the major questions doctrine. I regret to inform him that I'm not one. But it is so the key dispute here is that Kagan and the Sotomayor and Jackson, in part, although she wrote her own as well, they don't think you have to get to the major questions doctrine on this because they don't think it's a major thing. They just think it's explicit. Heavily paraphrasing and summarizing what their position is, but that's the dispute, is that a plain statutory reading of this gets you to know he can't do it. So we don't even have to go into is this a significant thing? Thomas and Kavanaugh blow that up, and they basically say no, it would have always been read this way. But the doctrine itself is that it should be explicit if they are delegating major authorities.
Okay, so
does that make sense?
Yeah, it does. The Constitution lodges the nation's lawmaking powers in Congress alone. Maybe that was where I picked that up. Let me highlight that. Lawmaking.
Well, so much of this is about what they mean by legislative. Like what are legislative powers? Are legislative powers all of the powers of the legislative branch, or are they just limited powers defined as legislative? And there's a whole bunch of disagreement about that.
The majors question doctrine safeguards that assignment against executive encroachment. Under the doctrine's terms, the president must identify clear statutory authority for the extraordinary delegated power that he claims. And as the principal opinion explains, that is a standard he cannot meet. Whatever else might be said about Congress's work in the IEEPA, it did not clearly surrender to the president the sweeping tariffs power that he seeks to wield. Not everyone sees it this way. Past critics of the major questions doctrine do not object to its application in this case, and they even join much of today's principal opinion. But they insist they can reach the same results by employing only routine tools of statutory interpretation, and this is directly in reference there to Kagan and Sotomayor and Jackson. Concurring in part, meanwhile, one colleague who joins the principal opinion in full suggests the major questions doctrine is nothing more than routine statutory interpretation, referring to Justice Barrett there. Still, others who have joined major questions decisions in the past dissent from today's application of the doctrine, meaning you're a hypocrite.
Oh,
Fine,
yeah.
and that's specifically at Kavanaugh
And
joined.
he
by
goes
Thomas
in
also.
great detail into all of the places in the
Mhm.
recent decisions where they held the other position when it wasn't Trump, when it was Biden.
So he is so that wasn't a shot at Kavanaugh, Thomas, and Alito. That was citing Thomas, Kavanaugh, and Alito, right?
No, he takes shots at all of them.
No. But I'm saying this statement here,
In this part.
still others who have joined major questions decisions in the past dissent from today's application of the doctrine. And this is referring to Kavanaugh joined by Thomas and Alito dissenting, right? That's what they're saying there.
Still others who have joined the decision in the past dissent from today's application. I think he's taking a shot at them.
Is he? Because then he goes on.
Gorsuch very narrowly agreed with Thomas and Kavanaugh on something, and I can't remember what it was, but it was a really small part of his rebuke of them. He rebuked everyone.
Finally, seeking to sidestep the major questions doctrine altogether, one colleague submits that Congress may hand over to the president most of its powers, including the tariff power, without limit. And that's the Thomas shot right there. Yeah. It's an interesting turn of events. Each camp warrants a visit. So let's visit it. Start with the critics. In the past, they have criticized the major questions doctrine for two main reasons. The doctrine, they have suggested, is a novelty without basis in law. Shot at Kagan and Sotomayor, calling the doctrine a special canon that has magically appeared. And they have argued the doctrine is rooted in a, quote, anti-administrative state stance that prevents Congress from employing executive agency officials to do important work. Today, the critics proceed differently. They join a section of the principal opinion that applies the major questions doctrine. In other words, when it was just, unelected bureaucrats, no big deal. We can let them interpret the law broadly. But because it's not just the president, but specifically, in my opinion, specifically President Trump, massive scrutiny.
Yeah.
To me, that's insane. That's the craziest part right there. And rather than critique the doctrine, they say only that it is, quote unquote, unnecessary in this case, quote, because ordinary principles of statutory interpretation lead to the same result. Unpack that last claim first. My concurring colleagues contend that as a matter of straight up statutory construction, IEEPA does not grant the president the power to impose tariffs. In doing so, they make thoughtful points about the statute's text and context. But their approach today is difficult to square with how they have interpreted other statutes. Dissenting in past major questions cases, they have argued that broad statutory language granting powers to executive officials should be read for all it is worth. Yet now, when it comes to IEEPA, similarly broad language granting powers to the president, they take a more constrained approach.
Yeah, this is just straight up pointing out the hypocrisy of the reading. And so the undertone there is the court is politicized. Yep. And I think it is. I think that's true. I think all of us would, agree with that. Sometimes we agree with what the court did because it supports where we, our view and vision of the country, where we want it to go, and, who's asking for the thing from the court. And sometimes we don't because it goes the other direction. So the question for us, if we're going to be intellectually dishonest, is what should it be? Controlling for our political passions and the person wielding the power. Should the power exist? Where should the power exist? Where is the authority to grant the power to the person who wants to wield the power? Take the emotional aspect of, Trump versus the world out of it. And because my personal opinion on this is we watch, lawfare, right? Mm-hmm. Getting plaintiff shopping, picking people to come in to bring a case into courts to change the law, or to shift, to set a precedent, to do something new, to change something we don't like. That's, that can be justice. If you're on one side of it, it can be lawfare if you're on the other side of it. But I think President Trump does that too. And I think that the agencies and the federal government are doing that too. Certainly the states are doing it. My governor has passed 54 laws against, my AG who is running for governor has brought 54 lawsuits against the administration.
Right.
So what does that mean? Well, President Trump and his team are probably going to fight some of those. They're probably going to settle some of them because they're not that important to them. They also might go, balls out to use them as a vehicle to put, in my opinion, the government, the branches back in their constitutional boxes and to take down the administrative state. So if your goal is everything president asks for, he should get, then you're going to be disappointed, right? But if your goal is, let me say it a different way. It's not about President Trump winning. It's about us winning. It's about the country winning, right? We're supposed to be giving power back to you, the people. That doesn't mean amass it in the executive branch under President Trump and then say, oh, fuck, when President Trump is out and we get President Newsom or whatever.
Yep. That's one
also, sorry, one more thing. That is not saying, just for folks so they understand, that is not saying the president doesn't have the power to do tariffs. It's saying that IEEPA doesn't grant the president the power to do tariffs.
Yeah, that's one of the things that, when a lot of these cases that have come up that President Trump is challenging policies and whatnot, that is one of the things that I've seen is the most difficult thing for MAGA to do, is to look at it through the scope of, don't think about it as President Trump. Think about it as this president and future presidents. Because once that precedent is laid, yeah, sure, it's great for President Trump, to be able to do these tariffs. It's I'm trying to think of another example. There's been so many where I've said I think President Trump's wrong on this, and I don't fear. Look at the FBI and some of the things that have gone on with the FBI and some of the warrants that have been served and things like that. And you look at them and you're like, yeah, root for this. But just remember, the shoe will be on the other foot at some point, right? And if that same type of, whether it's weaponization, and granted, I understand the DOJ has been weaponized against MAGA for a decade or more now at this point. But that's all. The point that Ash made, I'm with you on that 100%. And it's one of the hardest things I see people, getting kind of blackpilling over Trump losing some of these cases. But, it's precedent. Just like when we go back and look at, some of the things that Obama had done, or not Obama, that Biden had done to President Trump, the executive immunity, right? Executive privilege and the immunity cases that set precedent. So.
Yeah.
All right. Consider some examples of how they have proceeded in the past.
Part. This part is so savage because he just rubs their noses in it.
Yep. Dissenting in National Federation of Independent Business versus OSHA, two of my concurring colleagues confronted a statute charging the OSHA with promoting safe and healthful working conditions. Joint opinion of Breyer, Sotomayor, and Kagan. They read that language as authorizing the agency to impose a vaccine mandate on 84 million Americans. In support of their reading, my colleagues stressed the statute's quote-unquote expansive language, another provision authorizing the agency to issue quote-unquote temporary emergency standards, and quote, the scope of the crisis the agency was trying to address. In other words, yeah, OSHA had the authority to issue vaccine mandates because, well, the statute's broad and it just says, do what you got to do to ensure safety.
Yeah. And someone in the chat wrote that the court didn't constrain Biden. And I don't know what the context of that statement was, but the OSHA mandates are a good example of where the Supreme Court did constrain the Biden administration. Now there is the precedent, the law of the land is that the government can do vaccine mandates, but it's the state government that can do it. The federal government cannot do it, but state governments under the cases Jacobson, they absolutely it's actually today is the anniversary of that case, which is why Jacobson, it's like it's top of mind for me because that decision came down. It's like 1905 decision that upheld states having the right to do vaccine mandates in response to the smallpox pandemic, but the federal government does not have the right. And that's a good example of where, I don't think there should be any vaccine mandates, but the federal government cannot do them.
Correct me if I'm wrong, though, but in Jacobson, wasn't the punitive damage, like, wasn't the punishment like a $5 fine?
I don't have that up. I don't know.
I'm pretty sure it was like a $5 fine. It wasn't prison time.
I think I have the entire thing linked. My Substack isn't up today, but the opinion of it is linked in my Substack today, I believe.
Well, I'm pretty sure it was. Somebody can fact check me on that. But either way, I don't think they should have the authority to put you in prison because you refuse to put something in your body,
or to force you to take it.
Right, especially if it doesn't meet the standards, the health standards and testing and everything else that's required. So, dissenting in Alabama Association of Realtors versus DHS, Department of Health and Human Services, my colleagues addressed a statute permitting the CDC to issue regulations, quote, necessary to prevent the transmission of communicable diseases, end quote.
You're correct, by the way. It's $5.
$5, yeah. As they saw it, those terms granted the agency the power to regulate landlord-tenant relations nationwide during COVID-19. In reaching this conclusion, my colleagues again highlighted the statute's quote-unquote broad language and suggested that it permitted the agency to impose even greater restrictions than the ones at issue in the case. Dissenting in West Virginia, my colleagues faced a statute allowing the EPA to ensure power plants employ the, quote, best system of emission reduction. They read that provision as authorizing the agency to effectively close many power plants and transform the electricity industry from coast to coast. Major questions doctrine. That's a big implication for the nation. In support, they once more argued that the statutory language was, quote unquote, broad and expansive with no ifs, ands, or buts. They stressed, too, that the relevant statutory terms appeared in major legislation intended to address, quote unquote, big problems, and that the statute authorized actions in the agency's traditional lane or wheelhouse. And then finally, dissenting in Biden versus Nebraska, my colleagues took up a statute permitting the Secretary of Education to waive or modify any statutory or regulatory provision applying to a federal student loan program during a national emergency. They said that language allowed the secretary to cancel $430 billion in federal student loan debt because of COVID-19. Just let that sink in for a second. You're talking about these liberal justices saying it's okay for the secretary, an unelected bureaucrat of the Department of Education, the education secretary, to cancel $430 billion. Guess who foots the bill for that, by the way? We foot the bill for that.
All of it.
The secretary can cancel your debt, but the elected executive of the United States, the president, can't impose a tariff on a foreign country that would ultimately help alleviate some of that debt that we're burdened with. That's crazy.
Yeah.
That is nuts, man. By the way, Joe Biden did everything he could to get around that ruling, by the way. And
yeah, and they had these ladies tried to help him. They were his advocacy for that position, which is the opposite of the position that they're taking in this case, which is the point Gorsuch is making, and it's delightful.
Yep. Once again, they argued that the statutory terms were broad, expansive, and capacious, and designed to afford the secretary a potent power to respond to national emergencies that were major in scope. Now compare all that to how my colleagues proceed here. This case, they say, is nearly the opposite. That's a direct quote. While straight up statutory interpretation granted executive officials all the power they sought in all those other cases, my colleagues insist this one is different because IEEPA simply does not give the president the power he wants. That's a striking turn given the statutory terms before us. When the president declares a national emergency, quote, to deal with any unusual and extraordinary threat to the national security, foreign policy, or the economy of the United States, end quote, IEEPA permits him to, quote unquote, regulate importation of any property in which any foreign country or a national thereof has any interest, end quote. Surely the authority granted here is broad and expansive. It has no ifs, ands, or buts either. As a matter of ordinary meaning, the term regulate means to fix, establish, or control, adjust by rule, method, or established mode, direct by rule or restriction, or subject to governing principles or laws. And tariffs do just that. They fix rules that control, adjust, or govern imports of property in which any foreign country or national thereof has any interest. That one confused me, Ash, that line right there. Why did he concur with the opinion if that's the case?
Which part? And tariffs do just that. They fix rules that control, adjust, or govern imports, because his point is where that authority lies. Not whether or not the authority exists, but where it falls within the structure of government. And his position is that it falls in the legislative branch. I disagree with him a little bit on some of this stuff too, which I'll point out when we're.
So to me, it felt like, and I even made a mistake when I put my tweet out on this. I did a little thread on it, and I said Gorsuch dissented, and I couldn't edit it because I didn't realize that it sounds like a dissent, right? This sounds more like a dissent from the majority opinion.
I think it sounds like a lecture. He's giving us a history and legal lecture in this.
That's the point I was getting at, is I feel like he did this more like his vote could have gone either way. His ruling could have gone either way.
Yeah.
Like just based on that statement alone, tariffs do just that. They fix that control, adjust, or govern imports. He's saying that this is the Black's Law definition.
Yeah. And tariffs will continue to do that when the tariffs are wielded by the Congress versus the executive. I don't find that at odds. It's just where he finds that power resides. And we'll continue.
I think he took a principled stance on this. I think this is an opinion on principle and not necessarily on the merits of either way. Go ahead.
Yeah, I mean, the part that I have a problem with is two things. Reconciling his position here with the positions that he takes in overruled about there being way too much law and about the power that Congress is wielding. And I have that clip. I have that cut out of the decision so we could talk about it. It's at the very end though. So it's like his last paragraph. And then the other part of it is elections. It all relies upon real elections, because the reason he is his position as to why this is a legislative branch authority versus an executive branch authority is that it has to be representative, because tariffs are a tax, duties are a tax, fees are taxes. This is, disputed by people that want to levy fees and taxes on you, but pretty much all of us realize and agree that it is a tax. And if we're going to be taxed, it has to be, no taxation without representation. So you can't have a king that wields the authority to tax people or businesses or whatever, because that's not representative. And that's the position, that is the principled position that he's taking. Therefore, I argue, real elections are the most important thing, because we don't have representative governance right now. We don't have a representative republic right now. We have a black box by which we are told who is anointed into seats of power, and then they do whatever they want with their own sets of rules that govern them. And so you can't ask us, and his note at the end is written to us. It's not written to his colleagues. Most of this is, written to his colleagues in effect. And he sounds amused as he's writing it, right? Like, it's like you can see he's kind of disturbed and a little bit amused at the positions that his colleagues are taking. But at the end of it, he's writing to us and he's cautioning us to use temperance in wanting President Trump to have all of these powers that maybe you don't want, President Newsom or President Polis to have. Bingo. Right. And I think that that's correct. However, because they have to be representative powers, that representation is the most important thing, and it can't be fabricated, because that's not representation. Those people in those seats in the Congress, those people are actually the most important people to make sure that they're there for the will of the people, because the authorities that they are given and protected by the court, their authorities are protected by the court. because they are the representative bodies, because they are put there through in small faction, small, I mean, 900,000 people here in CD4, but smaller faction. They are put there to represent their interests such that we cannot be taxed or tariffed or have duties levied upon us without our representation. He's right on this. However, elections are fake. So we're all screwed, and Gorsuch should, not be upholding the virtues of which he does at the end, which we'll get to eventually. So, anyway.
All right. Without question, IEEPA is also a major legislation designed to address big problems and crises, along with emergencies that are major in scope. By its terms, the statute applies only during declared national emergencies involving threats to the national security, foreign policy, or economy of the United States. And it tasks the president personally with responding to those emergencies, a responsibility surely more in his lane or wheelhouse than that of any other executive official, meaning he's elected by the people. He might, like Ash was just saying, your representative's 900,000. It's supposed to be 35,000, but 900,000 per person. Well, the president is 330 million, allegedly. So it's still an elected person, more so than any bureaucrat who is not elected. Okay. IEEPA grants the president the power to impose even greater restrictions than tariffs, sanctions, right? That's the crazy part right there.
You can ban a country.
It says
you can ban a country, you can tariff them.
Yeah, that's nuts to me. I mean, look,
it probably comes down to the law was written in the shitty way because the people in Congress are retarded. Yeah. I mean, it's probably an unforeseen loophole. It's possible they didn't mean for that limitation to be there, and that they did mean to, delegate the authorities, as Justice Thomas argues, but they didn't. It comes down, and in the major questions, it comes down to how it is explicitly written. And if the past 6 years have taught me anything, it is that so much of our reality is due to shitty legal work, shitty legislative work.
When I read these opinions and dissents like this, and I see like cases from like the early 1800s and stuff, all I can think is, as this guy's writing this, as this Supreme Court justice is writing this, he's got clerks that, are able to just jump on a computer and look up any case from as far back as they want. But imagine doing this in just go back to like the 1940s and having to find this, like manually go through just room full of documents and filings and everything. It's just how much shit in our law, just got buried. It just disappeared. Like we forgot about it. And you find some obscure ruling from like 1812, that changes everything.
Yeah, or 1905, where they said, yes, your state government can absolutely force you to take, how they did the smallpox vaccine back then? Like it wasn't the nice little sterile needle that you get today. And that was what they were like, yeah, it's totally fine for the government to mandate that. They don't always get it right.
It still isn't a nice small little needle. They give it to you, and because I got it in the Marine Corps, they give it to you and they say, don't touch the wound. And if you do touch the wound, don't touch your eyes because you'll go blind.
Nice.
And some schmuck tried that. He actually went and
of course. Did he go blind?
He did. Not permanently, but he lost his vision for like 3 days.
Oh, he's like, conspiracy theory. You guys are dumb. Oh, trust science is bullshit. Yeah. And then he went blind.
All right. Because the statute also permits him to nullify, prevent, or void imports, sanction, in other words. Why do my concurring colleagues read IEEPA so much more narrowly than they have other broad statutory terms found in other major legislation addressing other emergencies? Trump derangement syndrome. No, he doesn't say that, but that's what the answer is. They say contextual clues justify a narrowing construction here, but what the concurrence calls context looks remarkably like the major questions doctrines rule that when the executive branch officials claim Congress has granted them an extraordinary power, they must identify clear statutory authority for it.
And here's the thing. This is like one of the things that is so much fun about the age of Trump, right? Is that Kagan and Sotomayor and Jackson, they absolutely agree that the federal government should have these expansive powers and that the administrative state, supported by all of its experts, should be able to decide these things. But Trump. But Trump makes them take the opposite position of their long-held positions, and we see this all over the place. It's hilarious. Is that the end of your highlights?
I do have one more section right here. Let me pull it back up. If my colleagues all but apply the major questions doctrine, maybe they are simply if my colleagues all but apply the major questions doctrine today, maybe they are simply recognizing what they have in other separation of powers cases involving the delegation of legislative power, that the guidance needed is greater when the executive branch seeks to take actions that will affect the entire national economy. Or maybe my colleagues believe the power the president asserts here outstrips even those powers executive officials asserted in our past major questions cases. But whatever the case, my concurring colleagues' course today suggests that skeptics owe the major questions doctrine a second look, all of which leads me to take up the challenge they have posed to it in the past. Is the doctrine really some special canon that has only recently magically appeared? Love it.
Spoiler alert, no, it's back in the Federalist Papers. And he goes into great detail about where that is. And we get an extensive history lesson. There's a couple things I want to pull in here. See if I can read the, oh, wait.
It is TDS, E.H. Kyle. Yep.
So here he's talking, this is getting towards the end. Actually, let me, before I do this one, let me do this one. So he talks about Chevron and how there was tension between the kind of administrative state authorities when Chevron was in place. And here it says, it's no mystery why the court proceeded this way when interpreting legislative directions to the executive branch. Article 1 of the Constitution vests all federal legislative power in Congress. Article 2 charges the executive branch with seeing that Congress's laws are faithfully executed. In a very real sense, then, when it comes to legislative power, Congress is the principal and executive officials are the agents. See generally G. Lawson Seidman, A Great Power of Attorney, et cetera, et cetera. So what is the basis for the charge that the major questions doctrine represents a magical innovation? Part of the answer may have to do with the fact that in the latter half of the 20th century, this court began experimenting with a very different approach. The court pushed aside its long-held skepticism of claims to the extraordinary delegated powers and began affirmatively encouraging them. Chevron deference is just one example of this phenomenon, though a stark one. That case established a presumption that it was nearly the opposite of the major questions doctrine. When Congress failed to speak clearly, courts put a thumb on the scale in favor of delegated power. And he goes on to say, I don't know if you have that part, if you can pull it up. I quote tweeted it, but I don't have the actual opinion pulled up. I just had my screen grabs and I didn't have the second part of it. If you don't have it, I'll just give it. I'll have it in 1 second. I got it in 1 second. Okay. So he says that case, Chevron, established a presumption that was nearly the opposite of the major questions doctrine. When Congress failed to speak clearly, the courts put a thumb on the scale in favor of delegated power. Given that development, the long-standing principles animating the major questions doctrine may have receded from view for a time. After all, the two doctrines are often applied in the same places and counseled opposite results. But with Chevron gone, so is the conflict. This court's application of the major questions doctrine is not an invention so much as it is a return to form. And that goes back to putting these things back in their back the way they were. Put them back. We're not all of the progress in their dissents, or their concurrences, their hysterical concurrences. The 3 liberal justices talked about we can't get rid of all this progress. We've had so much progress, but have we? Have we had progress, or have we had an erosion of the principles that form our republic?
At the expense of our principles. Exactly.
Right. And so that brings me to this last one. This is how he ends his 46 pages. This is his very last paragraph. And like I said before, I think he's talking to us. For those who think it important for the nation to impose more tariffs, I understand that today's decision will be disappointing. All I can offer them is that most major decisions affecting the rights and responsibilities of the American people, including the duty to pay taxes and tariffs, are funneled through the legislative process for a reason. Yes, legislating can be hard and take time. And yes, it can be tempting to bypass Congress when some pressing problem arises. But the deliberative nature of the legislative process was the whole point of its design. Through that process, the nation can tap the combined wisdom of the people's elected representatives, not just that of one faction or man. Their deliberation tempers impulse, and compromise hammers disagreements into workable solutions. And because laws must earn such broad support to survive the legislative process, they tend to endure, allowing ordinary people to plan their lives in ways they cannot when the rules shift from day to day. In all, the legislative process helps ensure each of us has a stake in the laws that govern us and in the nation's future. For some today, the weight of those virtues is apparent. For others, it may not seem so obvious. But if history is any guide, the tables will turn and the day will come when those disappointed by today's result will appreciate the legislative process for the bulwark of liberty it is. And the problem I have with this, Brian, is that it's well, we're not, elections are fake. So the lawmakers are illegitimate. So they're not making laws as a result of the will of the people. And they don't actually have to have broad support. They have to have lobbyist support, right? We've got big problems with the way that laws are made. But the bigger part that problem that I have with this is it's at odds, a little bit at odds with overruled. And the positions that he takes in overrules about how corrupted the law has become and how the laws that have been in place for a long time, been in place since before Chevron and after Chevron, those laws are often incoherent and incomprehensible without delegating authorities to the administrative state. So go ahead.
Well, I would push back on that. I don't think overruled is about laws as much as it is about the administrative rules and regulations.
Sarbanes-Oxley.
What's that?
Sarbanes-Oxley.
But that's a misapplication of that law is the point. Yeah. Then that ties into Chevron. That is a misapplication of that law. Sarbanes-Oxley was meant as an accounting law, and it was used in overruled. It was used against a fisherman. And of course, during J6, it was used against protesters. So that's not a knock on Sarbanes-Oxley.
But a straight reading of the statute, and it's not just the Sarbanes-Oxley Act, it's Section 1512C of Sarbanes-Oxley, right? That talks about the destruction of evidence. And a technical straight reading of the law, as he's saying here, exactly as the words mean, right? It's maybe that's not a major question. I would argue that is a major question. That is life, liberty, and property, right? That gets into I think that
it's not national enough. I don't think Sarbanes-Oxley would be of national importance.
The J6ers,
still
all of the fishermen.
As much as we were concerned about it, it was all so here we're talking
every
about
corporation it applies to.
It applies to that, but the specific interpretation that we're talking about, the fisherman thing, doesn't apply broadly. Like there's no the interpretation of 1512C to apply to J6ers and the fishermen is a very narrow scope. And we may disagree with it, and we may all have gotten worked up over it, but the J6ers getting charged with 1512 did not have a direct impact on the nation as a whole. That's the point.
The interpretation of the statute did. That interpretation of the statute did because the statute, yes, it did. The statute, it's how you can apply it to fish and to J6ers because they're interpreting it very broadly. 1512C talks about destruction of evidence, and you're correct. It was intended in the wake of Enron. It was intended to address destruction of evidence in the wake of Enron, but it doesn't explicitly talk about just evidence in an accounting setting. And so it has been broadly interpreted to mean that broadly interpreted to apply to fishermen or to apply to J6ers. The position that Gorsuch is taking in this is that has to be the application parameters have to be explicitly said.
But the major questions doctrine means something that is going to have national security implications, foreign policy, or the national economy. And granted, 1512 being applied to a company like Enron could have, national implications. Right.
It did.
But the fishermen did not. And again, I'm avidly against it. And I think we both know that that was a misapplication of that law by the EPA. Was it the EPA?
But I don't think the major question is in the specific application. I think the major question is in the development of the law. Is the law being developed for a major question?
That's a good question.
Yeah, that's what it is that when the law is intended to address a matter of nationwide import, to delegate authorities on a matter of nationwide import, then
but major questions,
the delegation of the authority is, I think you're actually right, because the delegation of the authority isn't there. It is nationwide import, but it's not a delegation of a congressional to an executive branch authority.
Right. Major questions doesn't apply to the statute. It applies to the delegation of that statute to the administrative state. Yeah. I mean, I'm with you. I can make you could make the argument either way.
The delegation would have been to the SEC, right? To be able to review and enforce and whatnot. So you could actually, maybe.
But then it was park rangers that applied it to the fishermen and the DOJ that applied it to J6ers. So yeah, that went well outside the scope of the intended purpose. The one thing I'll bring up, so Gorsuch's, the way he closed that out was personable and kind of like a little hopeful, right? It's telling you like, hey, there's hope. I do think that the tariffs need to be reevaluated because Congress does move so ridiculously slow. And one of the things that President Trump did by implementing these tariffs was expose how neglected we've been, how like we've been like the cash cow of the entire world, charging us like these ridiculous tariffs while we're getting our asses pummeled in trade. And something has to give on that. Congress, like Gorsuch says, Congress moves slow. The world does not move slow. The global economy does not move slow. So, and this is something I talked with Chris about today on Badlands Daily. I think there needs to be an amendment to Article 1, Section 8 of the Constitution about the legislative authority to raise duties and taxes, and especially duties, because we're talking about tariffs here, and all tariffs are duties. Maybe perhaps something where a president can implement a duty and it can have, a predetermined course of a set time that it's allowed to be implemented until Congress is required to vote on whether or not to maintain it. Because President Trump has shown that the tariffs and duties that he's imposed are more than just taxes on other countries to do business with the United States. They're literal weapons. He is literally deploying tariffs as deterrents against armed conflict and saving lives in doing it. The India-Pakistan war ended because he said, I'll put a 250% tariff on both of you assholes if you don't knock this shit off. And they were like, hey, we're done. It's over. So I think there needs to be.
Do you want Obama to wield that power? Do you want Gavin Newsom or Jared Polis to wield that power?
With the checks and balances, yeah, I'd be okay.
Checks and balances?
Congress voting on it. Now. Well, my proposal was that the president can implement a temporary duty or tariff on another country and say Congress has 30 days or 60 days to vote on whether or not to maintain that or whether to essentially veto it, essentially. Because the way it sits right now, I think Congress is too slow and they just don't give a shit. They're too busy naming post office and getting their 5-minute clips and hearings.
Yeah, I mean, that's true. But also, I think that this isn't saying that President Trump doesn't have the ability to do tariffs. It's saying President Trump doesn't have that the IEEPA law doesn't give President Trump the ability to do tariffs. And he disagrees with that, but he accepted it. I have I think about 4 minutes of this.
Can I just add one thing before? Because it's a stipulation to my idea about, the president temporarily doing this. It would have to be enforceable somehow. There would have to be an enforcement mechanism behind it, because we've seen with the declaration of war that we haven't declared war since 1942 or 1940, whatever it was, World War II, when we declared war, when Congress declared war. And we've gone to countless wars since then. We have an unconstitutional treaty that we're in with NATO. Article 5 of the NATO treaty goes totally against our Constitution. It is an unconstitutional treaty, but here we are. And so, they use that and the authorization of military force and other things like that to justify delegating that power to the president to send our boys off to die. But God forbid we say, hey, China, you're charging us 40%. We're going to charge you 80%. That's fucking absurd to me.
Yeah. I mean, I think that, and President Trump says this, and I think this is the part here where he says what he's going to do in response to this. He has a ton of other authorities. This is a specific authority. And he said repeatedly throughout this speech today, now we have certainty about it. This was an open question before, and now we have certainty about it. And I think that that is a big part of what we're seeing in the courts. But let's listen to a few minutes of this.
I have the absolute right to license, but not the right to charge a license fee. So think of that. I have the right to license. It's a very powerful word. In many ways, license is more powerful than tariffs. In fact, I was thinking about using it. But they came up with the idea that I can license, just like the people that were opposing me told them to do, but not the right to charge a license fee. Think of that. Who ever heard of such a thing? What license has ever been issued without the right to charge a fee? You get a license, you charge a fee. It's automatic, but not with this court. But now the court has given me the unquestioned right to ban all sorts of things from coming into our country, to destroy foreign countries, but a much more powerful right than many people ever thought we even had, but not the right to charge a fee. How crazy is that? Our country is the hottest country anywhere in the world right now. And it was a dead country 1.5 years ago under an incompetent president. But now I'm going to go in a different direction, probably the direction that I should have gone the first time, but I read the language. I'm very good at reading language, and it read our way 100%. But
Super good at
now
reading.
I'll go the way I could have gone originally, which is even stronger than our original choice. As Justice Kavanaugh, whose stock has gone so up, you have to see, I'm so proud of him, wrote in his dissent, although I firmly disagree with the court's holding today, the decision might not substantially constrain a president's ability to order tariffs going forward. So think of that. The decision might not substantially constrain. And it doesn't, he's right. In fact, I can charge much more than I was charging. So I'm going to just start. Although I firmly disagree with the court's holding today, the decision might not substantially constrain a president's ability to order tariffs going forward. That's because numerous other federal statutes, which is so true, authorize the president to impose tariffs and might justify most, if not all, of the tariffs issued in this case. Even more tariffs, actually. Those statutes include, think of that, those statutes include, for example, the Trade Expansion Act of 1962, Section 232. All of these things I know so well. The Trade Act of 1974, Sections 122, 201, 301. And the Tariff Act of 1930, Section 338, all clear. But it's a little bit longer process. I thought I'd make things simple, but they didn't let us do that. I would like to thank Justice Kavanaugh for frankly, his genius and his great ability. Very proud of that appointment. In actuality, while I am sure that they did not mean to do so, the Supreme Court's decision today made a president's ability to both regulate trade and impose tariffs more powerful and more crystal clear rather than less. I don't think they meant that. I'm sure they didn't. It's terrible. And to think that the Democrats who oppose this only because they want to go the opposite way. They'd like to pack the court. They want to put on 21 people. They want to pack the court, pack the Supreme Court. Maybe they should do it. Maybe they would be better off if they did it. They want to pack the court. They want to do anything to hurt our country. There will no longer be any doubt, and the income coming in and the protection of our companies and country will actually increase because of this decision. I don't think the court meant that, but that's the way it is. Based on long-standing law and hundreds of victories, and even, as I was pointed out before, even thousands of victories over the years, to the contrary, the Supreme Court did not overrule tariffs. They merely overruled a particular use of IEEPA tariffs. And essentially, it's used to get a fee. I can do anything I want with IEEPA, anything. I just can't charge anybody for it. I can license, I just can't charge them. It's ridiculous, but it's okay because we have other ways, numerous other ways.
Were you going to say something?
No. That's just hilarious. I love that.
Yeah, I was going to go a couple more minutes where he lets Jameson Greer talk about what they're doing next, if you're cool with that.
Yeah, that's fine.
The ability to block, embargo, restrict, license, or impose any other condition on a foreign country's ability to conduct trade with the United States under IEEPA has been fully confirmed by this decision. So now there's no doubt, because, there were a lot of questions about tariffs because no president was smart enough to use them to protect our country from those countries and businesses that were ripping us off. You took a look at the deficits that we had with some of these countries. It was disgraceful what they got away with for many, many decades. But now we know, because this decision affirms all those things that some people weren't sure about. In order to
Have you heard that anywhere else? Has anyone in chat, have you heard that anywhere else except for President Trump or from right here on Badlands, that this decision affirms the authorities that he claims and that it's going to bring in more money into our country? Because all I've seen out there is doom and out and how the court is captured and they must eat babies and shit. That's where everybody's heads are at right now. And if you look at what President Trump listen to what President Trump is saying, and consider the goal. The goal is not that President Trump should get everything he asks for, because you don't want the next guy to have the precedent that he gets whatever he asks for. The goal is that President Trump's actions take us through the strategy announced on January 20th of 2017, where we are taking power from Washington, D.C. and giving it back to you, the people. That is not, it's not, here's the power, guys, right? It has to happen in courts. It has to happen in legislation. It has to happen in local communities, and people need to get up and actually start taking their role in it, whether that's in the public or the private space. But that's a mandate to all of us. And President Trump does not seem concerned about his ability to do tariffs. He does reinforce several times that now there is certainty on this question, though, and I think that's very interesting.
And it says so. In order to protect our country, a president can actually charge more tariffs than I was charging in the past period of a year under the various tariff authorities. So we can use other of the statutes, other of the tariff authorities, which have also been confirmed and are fully allowed. Therefore, effective immediately, all national security tariffs under Section 232 and existing Section 301 tariffs, they're existing, they're there, remain in place, fully in place, and in full force and effect. Today, I will sign an order to impose a 10% global tariff under Section 122, over and above our normal tariffs already being charged. And we're also initiating several Section 301 and other investigations to protect our country from unfair trading practices of other countries and companies. Thank you for your attention to this matter. And I say quite simply, which I've said for a long time, make America great again. And interestingly, we've already made it great, so I don't have to use that, but I don't think we'll ever give up on MAGA. MAGA is always going to be with us. People that brought the laws knew full well, but I don't think the court meant it.
You're muted. You're muted.
Sorry, I thought he had Jameson Greer talk about the specific things that they were going to do, but now he's going to questions, so I must have missed that part.
He does. He gets a question about foreign influence over the Supreme Court and gives a very cryptic answer.
You'll find out.
Yeah. You'll find out. Very interesting.
Yeah, there was one other cut. I mean, what did you make of that speech? Because I imagine you watched that whole speech, right?
Yeah, I mean, I think that he's always like the ability in navigating through the law. He'll still have the authority, or through IEEPA and other trade acts, trade laws, to do this. It's not the end of the world. I mean, and this was a very small. I think this was only the tariffs with Mexico, Canada, and there was one other one,
the drug ones.
Right.
Yeah.
It was only those tariffs. Now, granted, those are significant because it was a lot of leverage that we had against Canada. It was a lot of leverage that we had against Mexico as well to crack down on the narco trafficking and whatnot. But I don't think this is going to handicap him too much in that regard. And I also, I said all along that this, like you said earlier, putting everybody back into their constitutional box. And I think that we've known all along that this would probably get overturned. Is it stupid? Yeah, it is. I think it is stupid that he can sanction countries, but he can't tariff them. That's absurd. But the law is the law. And
Right.
I'm going to cheer on the Supreme Court interpreting the law as the law is written and not as, a bureaucrat. In this case, I understand the president's not a bureaucrat. But if it wasn't the president, if it was the Secretary of Treasury, right? Treasury Secretary that interpreted that, getting away from bureaucrats interpreting the law and bending it to make it fit their will.
Yeah, the other thing I thought was interesting about this, in the 170 pages, is that the most interesting arguments are being forwarded by Trump's 3 picks, by Kavanaugh, Gorsuch, and Barrett. And Barrett is just arguing with Gorsuch about him misinterpreting and misstating what her positions are, but she is also making constitutionally grounded arguments. The other justices are just equivocating their political hypocrisy, and that's pretty fun to watch. But the core constitutional disputes are happening between the 3 Trump picks, which I find pretty interesting.
Agreed.
We have 20 minutes left, by the way, and we have not talked about the other cases. There's 2 other cases we were going to hit on.
Yeah, you want to talk about the Tina Peters?
Yeah, very quickly. Hang on.
Sorry. I was going to segue by playing our next sponsor.
Oh, okay.
It's finally here, our 2nd annual mega sale. This sale only comes around once a year, so take advantage of the best offers ever while you can. For example, save 50% on our Giza Dream bed sheets, as low as $29.98. And for the first time ever on TV, My Pillow mattresses and My Pillow mattress toppers as low as $99.98. And you save 50% on our Lux Pure 6-piece towel sets. Regular $69.98, now only $39.98. And our best-selling standard My Pillows, regular $49.98, on sale for $17.98. Wait on it, mega sale, only $14.98. So go to mypillow.com or call the number on your screen. Use this promo code to take advantage of our 2nd annual mega sale. But wait, there's more. To make the mega sale even more special, when you order right now, your order's going to ship absolutely free.
All right, mypillow.com, promo code Badlands.
And I promise you will be less upset about this ruling if you have a MyPillow mattress topper, because you'll just be sleeping so well you won't lose a single wink over it. MyPillow.com, promo code Badlands.
This is truth. All right, so the Tina Peters. Oh, that's not it.
That's not Tina Peters.
It's this one. The Tina Peters story.
Yeah, let me pull. I actually have the decision.
Oh yeah, pull that up. I have it linked in there, but I'll let you explain what happened. I already.
Yeah. So after the appeal that we covered back when it happened, so her appeal, Tina Peters' appeal on her conviction. So this is, the charges were wrongly assigned and tried. The sentencing was misaligned to the actual charges. It was a misdemeanor, not a felony. The sentencing was overly harsh. All of those things, that's still pending. This is not that.
Yes.
So do not conflate, to the people out there, just temperance, do not conflate this decision with the appeal decision, because the appeal decision is still pending. After that appeal hearing happened, Tina Peters' team filed a motion for bond pending appeal. So while waiting for the decision to come down, can, let her out. We identified a number, and I think that's a fair argument to make. During the appeal, there was a number of really pretty large issues with her conviction that were identified. Let her out while she's waiting for appeal. They said no, but the reason that they said no is the timeliness of it. So it's only 5 pages. I'll drop the link in the chat here in a second, and folks can read it. I encourage everybody to read it. The statute authorizes, it says here, 49 days for seeking appellate review in criminal case applies to appeal of a trial court's appeal bond. So 49 days is the statute. Then they have a 35-day extension that can be granted under the statute. And then after that, if there's good cause, there's like an 84 days that can be added for good cause shown. So even if you stack all of those things on top of each other, which is every, all of the parameters for each one of those requirements being met, you're at I don't know, Brian, how much math is that? Do the math for me.
49 and 35 would be 84.
Plus 84.
Plus 84 would be 168.
Yeah. So so this is 480, I think, days. Where did they have it written out? Yeah. We are more than 480 days have passed since the bond decision. So it was not appealed timely. That is why this is being disputed. There is nothing in the statutes that authorize them to grant this this review at this point. They denied it, but they denied it without prejudice. So she can bring it. She has to bring it back to the district court. She has to bring it back to Matthew Barrett. So that's the part that's like, Yeah,
and they didn't give
that's
her
rough.
Yeah, they didn't grant her a change of judge.
Yeah, they did not. She has to ask Matthew Barrett. Now, Matthew Barrett might be,
embarrassed,
rethinking his life right now because of how that appellate hearing went. And so it's not necessarily a bad thing to go for it, but it raises a question of why wasn't that appeal brought after when the decision came down? Why was so what they did instead was they went to federal court, and they explained that in their petition, and the court addresses that in their decision here, saying, well, you could have done both and you should have done both. And from a statutory standpoint, you didn't do this step, and now you're out of the window, the timeliness window to do it. It is not over, right? It's not, this is a motion that was recently filed that has been just now decided, and the appeal is still coming.
Yeah. The appeal hearing, the appellate hearing went so bad for the state, especially for Lisa Michaels, the senior senior assistant attorney general that litigated or argued it. It went so bad for them that I genuinely thought that the appellate court would be like, yo, let her out of prison, because there's a lot of issues that we got to weed out here. And I still think that there is a major civil rights case to be made for the fact that they don't have minimum security prisons for women in Colorado. And,
Sure.
I was talking to somebody about this, and they said
you're going to say a civil rights case for Tina Peters, and I absolutely believe that there's a major civil rights case for Tina Peters.
For Tina Peters, I think there is a civil, but I'm speaking about in terms of
generally about prison access. Yeah.
Right. So one of the arguments that they made at the end was that, she's 70 years old, Gold Star mother, first time offender, nonviolent offender. And she's being kept in a medium security prison because in Colorado, the only 4 prisons that they have that are minimum security are all designated for men. And that to me is a violation of your civil rights. It is an equal protection violation. And even if you want to get away from the 14th Amendment, because I hate it as much as most, it's an 8th Amendment violation. That's cruel and unusual punishment.
Yes.
When you have men that have done, similar things or far worse things, but still nonviolent, and they're in minimum security, but because she's a female and there's no minimum security prison, she has to be in a medium security with, some violent offenders. That's bullshit, man.
I think you're making a novel legal case about prison access in the context of Tina Peters, and that's fine to do that. I just think Tina Peters needs less novel legal cases and more like good, solid legal work done on her cases. And this was a miss. Not appealing the bond denial in a timely fashion was a miss any way you read it. And, trying to revive it now, the court is always going to say no. That's those timing statutory barriers, unless we're talking about something super, super egregious, it's pretty hard to overcome that the timeliness thing, because that's entirely in your control as the petitioner. It's as the person moving the court, it's entirely in your control to do it within a timely fashion. Now, as I said at the time of her appeal, I don't think there is a way that this court cannot grant her some relief. There has to be some relief in this case. I just don't think this motion was it. And so I wouldn't get, doomed out or freaked out or start screaming that all of the courts are corrupt, because this is a very narrow question. And it's grounded in fact and law, the answer to the question. The state's treatment of Tita Peters and the weaponization of the judicial process in her case is without excuse. And that was proven in the appellate court. I think it gives a lot of support to the weaponization of government claims and investigations that the federal government is working on. I think that Tina Peters' case gives them a bunch of ammunition, particularly against the state of Colorado and their government, but also the feds the prior DOJ and whatnot. And so this isn't over. It just, this motion wasn't the thing. So that would be my position on that.
I agree. I do want to get into real quick. So Fulton County appealed, Fulton County's, let me pull it up real quick. The chairman of the Fulton County Board of Commissioners, Fulton County's Board of Registration and Elections, and Fulton County as a whole has now petitioned for to get their evidence back that the DOJ seized, and they're using the federal rules of criminal procedure. I think it's 41G, which is an unlawful seizure of evidence. And they're making a Fourth Amendment argument here, saying that they didn't. It confirms that the warrant is equally unprecedented in its theory of probable cause, subjecting petitioners to an improper and unjustified seizure of their property in violation of the Fourth Amendment, which would require immediate equitable relief. And they're asking for them to return all the original evidence. Now, I'm not going to go through the whole thing because it's basically a rehash of all the evidence that we've talked about on this show quite a bit. But at one point here, the attorneys, and I believe the attorneys now that drafted this, Abe Lowell is among them, the famous, attorney that seems to represent like every single person, with the quote unquote deep state. Who else we got? We got Abby Lowell, we got Norm Eisen right down there. And I think those are the only two that I recognize directly, but Democracy Defense Fund. So, I mean, you got that there. So here's what I want to jump into. And I think I caught them in a pretty interesting predicament. I think they lied in this filing. So right here, they're talking about the missing ballots during the recount. They say, according to the affidavit, quote, on the day of the deadline to report the recount results, Fulton County reported a recount totaling 511,000 ballots, 17,434 fewer than the original counted. The following day, Fulton County then reported a total of 527,000 ballots counted. This account badly distorts the true sequence of events by omitting the benign explanation provided by the Secretary of State's investigative report. See the Macias Declaration, meaning Ryan Macias.
We love Ryan Macias. We're big fans on this show.
Well, it's ironic because he was also one of the corresponding parties on the email that uncovered the 511. Richard Barron, the director of registration and elections at the time of the 2020 election, was emailing Ryan Macias this information.
But, oh my gosh, the totals don't match. What are we going to do about it?
Well, I don't know that he said that, but
that was a paraphrase, not a quote. The assertion by Joe Rossi was that the Barron sent the file to Macias and the file came back and everything magically matched.
Correct. So let me read on. It says, as that report explains, the original deadline for the recount was December 2nd, Wednesday, December 2nd, 2020. But Fulton County was unable to finish scanning all of its ballots by that date. Okay, keep that in mind. Unable to finish all of their ballots by that date due to
on the first scan?
No, on the recount.
The recount, yeah.
December 2nd by the deadline. It says due to a software programming error. Jump down here. The affidavit misleadingly claims that Fulton County reported a total of 511,000 on the day of the deadline. In truth, that number represents the running internal tally of ballots scanned on December 2nd, Wednesday, December 2nd, a date on which it was understood that thousands of ballots had not yet been counted. Fulton County did not report 511,000 or any results to the Secretary of State, quote, on the day of the deadline. Okay, keep all that in mind. Now I got to switch screens here and let me pull this up.
And who filed that motion?
That was on behalf of Pitts, but that's Abby Lowell, Norm Eisen, yeah, and Yi Soo Jo, not Yi So Ju, which I said that earlier in the week. I misread that. Here we go. So now listen to this. Remember, their official representation is that the affidavit was wrong and that Fulton County did not submit a report on Wednesday, December 2nd, on the day of the deadline, and that they were still counting ballots and that this was acknowledged. So here was Richard Barron, the director of elections and registration and elections, talking to the Board of Registration and Elections, the board, not, listen to this.
Now, with regard to the recount, we concluded that on Wednesday night. We submitted our results, and then yesterday the state allowed us to do reconciliation.
On Wednesday, we submitted our results. The day of the deadline, they submitted their results. They didn't submit, hey, we're still counting. No, they submitted their results, and the Secretary of State said back to them, hey, y'all fucked up, reconcile this. He didn't say fucked up. I'm adding that. You see what I'm saying here?
What does he say anything about what they said?
No, he just said the Secretary of State wrote back to reconcile this.
Results. Wednesday night, we submitted our results, and then yesterday the state allowed us to do reconciliation. The results changed. On election night, we were at 528,777. We scanned in 527,925 votes.
So the point is like in that filing, you have them calling the affidavit a lie while telling a lie.
Yeah. And
that's a misrepresentation to the court. And they accuse them
under pain and penalty of perjury, Abby Lowell.
Yeah. Let me see if I can find real quick.
Spoiler alert, doesn't actually mean anything. They all lie all the time and nobody ever gets in trouble for it.
And not only that, let me share this screen real quick. So this is from State Election Board 2023-025. And Ash, read that Fulton County, Georgia tweet right there.
Fulton County, Georgia at Fulton Info. Fulton County has completed the recount of the November 3rd presidential election. Results will be released by the Secretary of State's office, 11:52 p.m., December 2nd, 2020.
So let me jump back over here. In truth, the number represents the running internal tally of ballots scanned by December 2nd, 2020. Fulton County has completed the recount of the November 3rd election, December 2nd, 2020.
Just before midnight.
The running tally. Fulton County did not report any results to the Secretary of State on the day of the deadline. Wow. Results will be released by the Secretary of State's office.
So they lied.
Bald-faced lie.
Why are they? Who are they protecting? Is it like Fulton is already totally screwed, so we got to protect Raffy? Can we call him Raffy? I feel like we can call him Raffy.
I have no idea.
You have to have some idea. You got to have a theory.
I think Rob Pitts knows what's going to happen. I mean, we had Julie Adams, who's on the board of registration on Badlands Daily on Wednesday. Unfortunately, we had a horrible connection with her. And so, yeah,
she was great. It's just the connection sucked. Yeah,
she was great. And I wrote an article on the Gateway Pundit about, her rebuttal to that filing. And they didn't get permission from the board to file it. Pitts did it on his own, which he's not allowed to do.
Third time he's done that, she said.
Yeah. They did it without a vote of the board. They did it without having a meeting, announcing a meeting. They did it by an email vote. I mean, they're just violating their own rules and regulations and laws up and down, left and right. It's insane what they're doing to get away with this. And if you read that filing, like if a lay judge that doesn't know, a judge that's not looking into everything, the filing is compelling if you don't know what's actually going on in this case.
Yeah.
And so my fingers are crossed, man. My fingers are crossed.
What are they crossed for? What outcome are you awaiting?
That the judge not dismisses this, but the judge dismisses that petition and says, piss off, denies it.
Oh, okay. I thought that we were crossing our fingers that Rob Pitts is going to prison, but eventually, I'm sure.
I mean, anybody that signed on to that should go to prison for that.
Nathan Wade
or be fined for
Nathan
that.
Wade needs to go to prison. He was a special investigator and was given direct testimony that the case that he was pursuing was not true, and he buried that. It ended up being sealed, and he pursued the case anyway. That's a violation of the rules of professional conduct and the rules of procedure. And again, nothing ever happens to them.
Yeah.
And they all violate it all the time.
Yeah, and that's the I'll land my argument here. That's the point, is we just watched lawfare for the last 5 years go against every single MAGA attorney. I mean, to the point where we can't get representation anymore, right? Where attorneys will not represent you if you're bringing an election case. What's that?
Project 65.
Yeah, exactly. And all of the, the John Eastmans, the Jeff Clarks, the Sidney Powells, Rudy Giuliani's, all of them got sanctioned out the wazoo. And you got a guy right here that's, telling a bald-faced lie, and nothing will happen to him. And the worst part is he's telling a bald-faced lie as he's accusing the affiants of lying. Yeah. And that's where the hope comes in, right? Because we expect that nothing is going to happen to them because that's what always happens. However, I have a hard time reconciling that being the goal with all of the exposure that has come around Fulton County, because you're going to have mobs with pitchforks and, tiki torches coming out of the woods. If we don't, if you don't get accountability for what happened in Fulton County, they've lied repeatedly. The forums like the state election board have helped them cover it up. Not the current composition of the state election board, but the state election board that allowed Charlene McGowan to get up there and say all of the things and then not have any rebuttal and just take what she said as true. That's where we're at. And what we have found is that was all obstruction at best. Maybe it was, they really, really believed that election deniers were just crazy, so they couldn't hear it. Not okay, man, because they violated statutes, they obstructed, and now they're outright lying in legal filings. Yep.
So something needs to happen, and I think if it's guarded hope, I guess, hedged hope. Because if we're going by what always happens, then nothing will happen. But hopefully we're doing something new, and that's where I'll land.
All right, guys, let's smash that thumbs up if you have not done so yet. Don Shell 76, good to see you, Don. Thank you for reading it so I didn't have to. We appreciate you both so much. I liked and shared, of course. I would still read it. It was fantastic.
It's really good. Yeah.
I'm not I don't have the legal jargon like down packed. I still have to look words up and stuff.
The word and hit look up.
What's that?
Just highlight the word and hit look up.
Yeah, that's what I'm saying. But so it's a slower read for me. And I don't go in depth on all the citations and everything else like that. And sometimes you have to, so I get lost. But
it was a pretty slow read for me, but
yeah,
I was
very slow.
Interrupted a few times. And also it was dense.
170 pages is going to read more like 500 pages for me when I go through this. So,
and the Supreme Court, they're not like double space like usual legal filings. They're single space.
No, but you do have like cover pages and
they're
all that.
They're very narrow.
Yeah, and it's narrow. Yeah. So, the Walrus sympathetic nose wipe, Ash.
Thank you. Yeah, my nose has been running like crazy today because the weather changed again. It got cold.
It's cold.
Yeah.
All right, and that'll do it. Ladies and gentlemen, again, smash that thumbs up if you have not done so already. And stay tuned. We've got Spellbreakers coming up. It's probably starting right now.
We're going to raid over to Matt Trump, and then I will see everybody on OnlyLands. Are you going to be on? You should come. John's not going to be on, so we need more people, so you should come.
We'll see. I always check in, and I'm like, if they have 4 people or less, I'll jump on. But you guys always have 5 or 6 or 10. So I'm like, all right, I'll just drink some wine and smoke some weed.
All right. Well, we'll see you guys over there. We'll raid you over to Matt Trump right now. Hit the like button and have a great weekend.
See you guys.
Thank you so much for joining us, and don't forget to hit the thumbs up on this video. And a special thank you to all of our advertising partners. Please remember to shift your dollars to support those businesses that support Badlands Media.